A few stragglers still out in the hallways, but that's their loss if they miss any of these undertakings. So I wonder if, for the sake of time, if I could ask the panelists that we will hear from to join me up here. Then we have you all in a row. If Klaus Decker and Bob Galloway, and by popular demand, Katharine Gourlie has been asked to join our panel in case you thought of one more question for Katharine during lunch. Okay, while we're assembling, with lunch behind us, and I mean that as a reference to the clock, not to any physical appearance from the luncheon meal, I would like to welcome you back to the panel discussion of anticipated developments in advertising, in legislation, and in policies. On November 17, 1988, I appeared with a delegation from ACA before the Standing Committee of Consumer and Corporate Affairs, who were conducting hearings on the subject of misleading advertising. There has to be a reason for a standing committee to sit, even if you may have to invent the reason for it. And I had a feeling, and I think Klaus Decker reflected on the same thing, that they weren't quite sure why they were sitting or standing, as the case may be. From the subsequent report, the Bureau of Competition Policy extracted some points for considerations for amendments to the competition bill. From Klaus, one 75-year-old, to another, ACA celebrated its 75th anniversary at the same period as the law on competition activities. What better individual than the Deputy Director of Investigation and Research in the Bureau of Competition Policy to talk about the preliminary positions that they have outlined and taken out to the interested parties for comment. By the way, the cautious comment from ACA was in great extent the result of consulting extensively with our legal counsel, but we think we have, from subsequent discussions, indicated that go ahead on all the amendments is clearly something we would like to see. Seeing that Mr. Decker was formally introduced this morning, it would seem safe to think that not much has changed since then, certainly not in any material fashion. So without any further ado, here is Klaus Decker.
Thank you, John. Lunch has changed since then. It was a good lunch, too. Thank you very much. I'm lucky I don't have lunches like this every day. Well, as I alluded to this morning, these changes in the legislation are, in my view, a normal and evolutionary extension of what we have had substantively since certainly since 1969, in terms of prohibitions against misleading advertising and deceptive practices. The committee took up calls for reform in the area of misleading advertising and deceptive practices that had been made since the mid-70s, and came with its report in June of 1988. As John said, his association and a number of other associations, interested parties, have made submissions to the committee, And I might say anyone who is interested in a copy of the report itself, I'll be more than pleased to try and see what I can do to get you one. I think there's still some lying around. Interesting to note, those of you who've seen it might have been a little surprised by its color. It was a purple colored report. The reason for that was it was an all-party committee which had unanimous agreement on the recommendations contained in the report, but they couldn't agree on whose color they should use, so they chose a fourth color that made this thing somewhat distinctive in my book, on my bookshelf. Now, I should perhaps quote, and again I'm going back to my paper, you find it there on page 11, the committee, while giving us grudging accommodation for trying to do the job with in enforcing the mandate with the resources we had, found or came to the conclusion that we should have more, but they didn't, of course, have any specific mandate to increase it, so we're still where we were before, or in fact have continued to shrink while the workload has grown. The committee said, among other things, several witnesses felt that there were significant problems with the present approach. The criminal process was viewed as cumbersome, costly, and slow, ill-suited to matters of this nature. One witness described it as a ridiculous misuse of society's resources. Another said it was too blunt an instrument, while yet another questioned its deterrent effect. So you can see from this little quote that there were opinions voiced ranging across the whole spectrum of possible opinions one might have on this subject. And in fact, a few years earlier, when the first thrust of government restraint came in the early 80s, we were subject of a 5% or 10% across the board cut and found ourselves at a position where we were very much unable to investigate as much as 40% of all complaints of substance, which we had defined as those requiring, in fact, a more thorough look at on the basis of a number of criteria I don't have to go into here. And we made a Treasury Board submission at the time when everybody said you must be crazy. And in that submission we said, look, members of the board, you either give us more resources, or the better way would be to abandon this whole area and forget about it, because you're looking silly trying to maintain the facade of meaningful enforcement of the statutory mandate when you're not doing it. And they bought that argument and gave us more resources. By the time, of course, we put the last one of those into place, we were in the next round of government restraint and budget deficit reduction, all this, which we are battling at this time. And the situation has, if not, has improved only marginally over a period, and is now going back down again because the demand for service is increasing. And it's for that reason, in fact, that from the enforcement agency's viewpoint, we are quite interested in pursuing these reform proposals, because we feel we can do a more efficient and effective job in bringing about compliance. Now, I've touched upon many of those areas this morning. I want to briefly reiterate the areas that we have chosen as being useful for further push, and on which we have consulted with the groups of organizations and people that I've referred to this morning. And that's the area of non-criminal adjudication before probably a competition tribunal or a panel of the tribunal. We haven't come to that stage. The second area is appropriate remedial orders, that civil orders that can address that problem. The third one is the area of interpretive rulemaking, and I'm very delighted to hear John say just a minute ago that he has no problem with this, because last time we spoke he had a little more of a reservation. on that score. You must have taken the letter I wrote you to heart, where I tried to explain this. We had perhaps not communicated as effectively as we could have on that point, and perhaps there will be questions, and we can explore that later. And finally, to get statutory basis for the acceptance by the Director of Assurance of Voluntary Compliance. Many of our provincial counterparts, of course, have had experience with this, and we've drawn quite heavily on that, both in the area of doing too little with this, such as you might find in Ontario, which has practically done nothing in terms of voluntary assurances, and BC, which had in its heyday of its Unfair Trade or Trade Practices Act, had perhaps gone too far and had, some have suggested, abused its bureaucratic power in bamboozling too many business people into providing assurances. Of course, they went beyond the advertising into a number of other trade practices areas. We hope to avoid those mistakes, and in doing so, of course, don't want to do it ourselves as an assurance by the Director, but want to also see that this is subject of a proper and fair appeal mechanism that would be built in, and while the details have not worked out, it could be that people have the right to go to the federal court or something if they're not in agreement with this. But then again, I should mention that the process will only come into play on the request, on the basis of the request by an advertiser in the first place. So it's not something that we would want to impose. I mentioned the consultation process that we've underwent in this last year, following our study of the various issues and the fact that we have left aside a great number of the recommendations that the committee had made. Among those recommendations for class actions, which upon which one could have two different views, and invariably the views are not shared by the consumers associations of varying kinds on the one hand, and the business associations on the other hand. The business associations don't want this kind of legislation because they feel they have a lot of reservations about the fairness of the process and everything else. The consumers associations, of course, they have their own particular viewpoint on the situation, are very much in favor of more comprehensive legislation that is directed towards reining in the business community. We have taken the view that maybe the safe view of declining to pursue the area of class actions because, and I should add, we had a consultative forum on that question in conjunction with other matters that the Director of Investigation and Research discussed with a wide variety of people from both the business and consuming and academic and legal communities. But our feeling is that if the federal government wants at all to consider class actions as an appropriate mechanism to use, and I'm doubtful that it wants to do that in the era of deregulation and decriminalization, all this sort of stuff, the government would probably want to review this in a broader context than in the context of one statute or one part of one statute administered by one department. It's a much more comprehensive question, and that should be carried by the Department of Justice and explored more fully before any recommendations are made. We want to stay away from this as inappropriate in the context of this particular legislation. That's our internal view. The other area that we have disagreed with is the recommendation that the Director of Investigation and Research should take substitute action on behalf of certain aggrieved parties, victims, or what have you. We find this incompatible with the role of the Director as a fact-finding statutory persona and the director's staff, and we don't want to get involved in that. We are now at the stage of having developed papers in the 4 areas, have consulted in the 4 areas, where we're going before the Departmental Executive Committee for further input in terms of our colleagues on the Consumer Bureau side and other components of the department, before going to the minister and saying, look, this is what we've got. We had a little bit of delay and problems with changes of ministers, and so there is no official ministerial sanction on the proposals at all. We expect that the minister will be favorable towards the proposition that we should go on with the project, and if that is the case, we want to set up a small working group in the next month or so, consisting basically of no more than 5 or 6 people, a member from sort of John's class of clients from the business community, a member from the retailing side of the business community, a member from the consumers groups so that their views are properly canvassed, and a member from the department, 1 or 2 perhaps, only 1 member or perhaps 2 members from the department. These people in turn, we expect should select a final member from a list that we would provide to them from recognized academics in the field who could possibly act as a chairperson for the group and provide a more reflective view and settle arguments and provide a deciding vote or something of the sort. We'll have to see how that works out. That's what we envisage. It's the only way, I think, to be in a position to move forward with real proposals that have hand and foot and that bring to the table all the elements necessary to reach a broad-based consensus, because we don't believe there's any sense in getting to Parliament with proposals which in the committee stage will require everybody to go all over into a consultative process and try to put their 2 cents worth in and get the whole thing dragged in and dragged out. The Competition Act only got its final approval, if you will, when an approach such as this was used. So that's where we stand with this. I should briefly mention one more element of statutory changes that we have been looking about, and that's in the area of multi-level marketing. We have in the Act, as many of you will be aware, a section that prohibits with penal consequences the induction of anybody into a scheme of pyramid selling. The Act then proceeds to define what pyramid selling is, and this definition is not an easy one to read and an even more difficult one to understand. I still, from time to time, have trouble with it. When I'm thinking of 3 things at the same time, I'll have to drop the other 2 and, you know. And in consequence, the industry itself, through the offices of the Direct Sellers Association, the DSA, has made representation to the department for a number of years trying to get some changes, and we've had dialogue with them. In 1983 we came very close to an agreement, except again within the industry there was there was again some disagreement on certain sections, and the matter did not move forward then. Consequently, further agreement was reached under which we basically would reduce the current requirement of controls over override bonuses. This is when people get bonuses basically for recruiting rather than for the sales of the product, in exchange for stricter controls on inventory maintenance, having refund policies that allow people to return unused products, on the specific advertising or specific representations in terms of earnings potential that are often made with rather religious fervor in recruiting meetings and so on. However, the legislative agenda of the government and the parliamentary situation have, and the fact that we had changes in ministers for a variety of reasons having nothing to do with the substance of this matter, have all contributed to a delay. The Collins Committee report in itself has clearly, in my view, created a situation where if we are to consider these changes to this particular section, which finds itself within the broader context of the misleading advertising provisions of the Act, we should consider them together. And so if we move forward with this, my vision is that we will at that time also look at the changes to the pyramid section. The matter has been further complicated by the fact the minute the director reached agreement with the industry on some basic areas, the Supreme Court of Canada in the Shackley case upheld the section as it then was, or as it still is, and puts us in a bit of a dilemma in terms of enforcement policy. But having limited resources, we're getting around this in the best way we can. In the meantime, the section, as it stands now, is still the law of the land, and we're doing our best to enforce it, given the resources. That's all I have to say for now.
Thank you, Klaus. Thank you, Bob. Now we have time for some questions to the complete panel. For those of you who may have saved them up, we may not have time for any answers, but we tried to fit in your questions. Seeing that Katharine Gourlie has joined us at the panel, I wonder if we should give you the opportunity to raise any questions you may have of what the panelists have said. Has anything come to mind that you heard from, or are you willing to be thrown to the
I'm willing to be thrown
audience?
to the wolves.
Okay, then here, audience, is your chance. Anyone has a question for any one of the panelists?
Don't speak all at once, please.
It's amazing. I thought it would be teeming with questions here. I think it's the only reason is that you've been so total and complete in all your commentary that there is no room for any further questions. Just to start the ball rolling, during this morning a couple of references was made to credulous man. I thought that had been pretty well sort of dispensed with back in time when it was much more prevalent, and that reasonable man was reinstated. But I think I heard that in a selective way, credulous man concept may still be applied if the claims are sort of directed to a broad enough segment of society. Would you care to comment on that, Klaus?
Yes, I can. I'm just looking. I think there's a reference in the paper to this. When I talked about this morning, perhaps I should have finished off my comment that's perhaps not quite complete, because we were a little concerned that all of a sudden we'd have to chase after every funny, humorous statement that was strictly an exaggeration in the form of hyperbole, and clearly intended and put forward as such. We were encouraged to learn through subsequent years of jurisprudence that the credulous man doctrine has not taken a foothold, because then we truly would need the army that Holly was talking about. I think on page 2 of the appendix to the paper we're talking about, and let me quote, although the law has been found to be directed towards the general public, including the ignorant, the unthinking, and the credulous, that standard has been diminished by subsequent decisions, and we have a number of decisions there. One is mentioned in the footnote is a Regina versus Eaton's in 1975 decision, where the readers of an advertisement were assumed to have had some common sense. And of course, the international vacations, I think Ollie referred to that earlier this morning, is also a case that have reestablished the average man as opposed to the great unwashed, unthinking person. So we are happy with this because we don't see that in any reasonable terms we would want to get involved in having to chase after every crack bar.
Katharine, does it play any part in any of the assessments of advertising claims that come before your team of people?
Not really, not really. I think that, as I indicated, the general impression test is applied and against the whole of the presentation.
John, if I may.
This front row to, we'll say him.
This morning, I wonder if I could switch just for a moment. This morning, I was intrigued by your comment on advertising and trademarks. And perhaps later I could talk about that. But you said that you were concerned about advertisers' use of trademarks. And I wasn't really sure where you're coming from, because from my standpoint, if an advertiser wants to do something with his trademark that spoils it or ruins it or changes it or makes it into a commodity of a particular class, that's his business, and it's done every day, unfortunately. I think as advertisers, and I make the point now, I think in advertising we have one of the most important aspects in trademark properties, because by our actions in advertising we either strengthen and build those marks over time, or with one sweep or of a campaign can demigrate them, and we can lose the great marks and make commodities out of what are very viable markets. So I was wondering how you would relate to trademark matters as they come through you in the normal advertising approval process.
Well, it's in the context of the registered brand name or the trademark brand name, which has been developed and which has been applied and which has been sold as representing a certain very precise category of product, which meets certain conditions. It may fall within a certain regulatory environment, and because that name is well understood, for example, let me just suggest that one that doesn't exist, but
Use Campbell.
well, no, I won't use Campbell's because Campbell's isn't appropriate. Okay. So hard of thinking of, but it's in transferring that to try and get the same value of that brand name into a totally different category of product or good to which it has absolutely no meaning. And this is where in my paper I suggested this: a rose is a rose is a rose until I want to decide that it's a lemon or a tree or something like that. And yet there's tremendous resistance sometimes, and at first blush, to agree to or to respond to our request that there be some explanatory statement added or some modifying qualification be added to the presentation of the brand name. And this is where I find it very difficult because I'm dealing with commercially sensitive situations, some of which are still under discussion, and I really don't feel I can use too many to use examples.
Part of Campbell's Campbell's one of two. Campbell's came in with different products, like some drug products, you might know. They say you have a problem with that. Is that transferring from two products?
No.
I wouldn't have a problem with Campbell's vitamins, but I might have a problem with Campbell's soup trademark vitamins.
But I don't think Campbell's trademark is Campbell's soup. I think it's for Campbell.
Exactly.
Color coordination.
Exactly, so I don't have a problem with that. But where I would have a problem is if you came and said to me, I want to call my product my vitamins, or I bought an drug company, but, you know, the company's name is well known, and I want to change, and I want to use Campbell's Soup aspirin.
For the soup itself, indicates.
Because soup is part of the trademark name, if it were. If it were.
I think I see the point that if you had Campbell's on soup, it's well recognized as a soup trademark, and it's well recognized as having a certain level of quality. I can see that you might have an objection to immediately transferring that mark onto an unrelated product. I think I can see that point.
Yeah.
You may not want to support Campbell on a drug product.
No.
But provided we were approved for use, Campbell's Soup is not marked by the way Campbell is, and we're approved for use, such as soup, etc. And if we got approval for use in vitamins, it seemed to me that's completely our prerogative to sell vitamins under the Campbell logotype.
And I would have no problem, but if your name was Campbell's Soup, if your trademark name was Campbell's Soup, and soup had been the only product that you marketed, and you came in and said, I want to market Campbell's Soup. Exactly. Well, we do.
Campbell on another product seems to be entirely permissible.
No problem.
On
No.
this side,
You
I
know,
think.
as I said, it would be so much easier if I could be more precise.
No, we don't. We give greater weight to a complaint by a competitor. That is weight in terms of the priority which we attach. The reason now this is marginal. We get 13,000 complaints, as I mentioned, plus here, we haven't had an actual head count lately, but the percentage of competitor complaints, as I mentioned, has gone up from about 6% now. I think it's probably around 8% of the total, as opposed to consumers, and that has to be expected. I think because consumers, and we have some third-party complaints that come into this 2 or 3%. People are just interested and want to bring something to our attention who are neither a consumer in respect of that particular matter or a direct competitor. However, our experience, and we made some studies a couple of years ago, has shown that competitor complaints have a chance of winding up in court that is 8 times as high as consumer complaints. And upon reflection, that's not surprising, because competitors are, first of all, given a historic penchant, if you will, not to squeal upon your industry colleagues, which is changing a little bit, as I alluded to this morning. But given that, they are not likely to complain unless the matter is fairly serious and they are really disadvantaged and feel something ought to be done about it. Secondly, of course, competitors have a much better knowledge of the product, of the market, and the whole situation. And in consequence, complaints of this nature are usually contain much better basic information to start with and make an assessment. The assessment is based on similar criteria or on criteria that apply similarly to our complaints. But since competition, maintenance of competition, is one of our objectives, stated objectives, and the straightforward consumer protection is not. We give competitor complaints greater weight than we do complaints from consumers. One final aspect that comes into play is the fact that, and I alluded to it I think this morning too, that many deceptive practices have no detrimental effect on consumers, and particularly the cases in where we're talking about misleading price representations as to the ordinary price, regular price, reference to discounts of the manufacturer's price, and so on. And that's why the very first section, as I mentioned, was brought in at the behest of retailers who came and wanted some protection against this sort of stuff. the consumer may indeed, and does with many of these representations, receive good value for money, or the best price at which the product in question may ever have been offered on the market, relatively speaking. So there's no consumer detriment, even though the price, the comparative price representation is way out of line. If the product normally, let's say, give you an example, the product sells at $30. The representation is today's price $15, 50% or $20, 50% off regular price. Now the consumer still gets the product at a very good price, better than it's been sold before, when it was regularly sold at 30. If it's now represented to be a 50% off a $40 price, then obviously someone has a detrimental effect, and that effect is the honest competitor down the street, who has business drawn away from his establishment in favor of the person who makes that representation. Similarly, when you use other comparisons in this regard, you may find that the consumer does not in fact lose anything. So it is the business person, and that's why the Act, and we try to stress this whenever we can, and I'm seizing upon this opportunity to do so. While many of the sections are clearly containing a consumer protection aspect, there's no question about this, and we're not trying to deny that, but that's one aspect. The other aspect is the protection of the marketplace and the players in the marketplace, the business people. There's a high degree of protection of small business against big business, some business against other business, honest business against dishonest business, and so on. And that's, of course, one of the fundamental precepts of the Competition Act as a whole, that efficiency and effectiveness in the market is maintained through an efficient marketplace in which there's product choice, in which there are no restrictions to entry into the market, or no artificial restrictions, imposed restrictions to enter into the market, and so on and so forth. And in the area of the consumer information side, where there's open and accurate and reliable information on the basis of which people can make a rational choice. Take many of the scams that operate today. They're not directed to consumers. Many of the telemarketing is directed towards small businesses who are invited to buy certain supplies on the guise that they are the brand name, when indeed that they've always been buying, when indeed that's not true. Take many of the invoice appearing solicitations that come to small business, doctor's office, dentist, professional offices. You may have received them yourself in your legal offices. They look like an invoice, but they are in fact a solicitation. And if you're not careful, you're paying these people $350 for some directory that you may never want to look into. You're getting the directory, all right, there's nothing wrong with that, but you don't want it. But you think you're having an invoice. And in fact, Katharine mentioning this morning the disclaimer in small print on, black on brown paper and upside vertical. Well, we had a case against Intra Telecommunications and Ralph Devine, one of those people who used this kind of system. He had this disclaimer, all right, because post office regulations require that you have a disclaimer on. It must be in letter on the front, first of all, not on the back, and it must be in letters not smaller than this. And this chap had put the disclaimer on, right? But it was too small to meet the post office regulations. And what he had done was he ran it in uniform print, and either, I think it was all majuscule or all minuscule, small print, big print, I forget. But it was run with no spacing, one letter after the other. And in the representations to the English-speaking community, he started with the French, and in the representation of the French-speaking community, he started with the English. So nobody had a chance ever to get through that disclaimer. And I get nods from my people there who know what this stuff looks like. So we got a conviction, and he was personally convicted. one of those cases where there's clear individual culpability. The guy knew exactly what he was doing. Well, it was a clear case of mens rea, no question about that.
Thank you. Time is running away from us all together, but I'm bound to recognize second row for one question. You had... It has been answered? Okay. Well, I guess I'll have to recognize my co-chair.
You better.
What do you,
Okay.
planning committee, recommended regulation?
Yes, they did. They did some of that.
And, the position of the emergency crisis management,
We don't want regulations per se. What we think would be useful is interpretive rulemaking, where we would go in with certain phrases that have built-in confusion. Made in Canada, what does it in fact mean before an advertiser? Sort of a guideline, if you will, that goes somewhat beyond this, but we would want to have consultation with the affected industry or the business community in general, and we would want to go to order and counsel rather than give the right to regulatory authority. We don't want regulatory authority for the
bottom line then would be that once a decision is taken,
That would be the law as regards this, but we see, it's hard to make estimates, but we see no more than the odd situation in which this would apply. We do not see a plethora of, to use your term, of regulations sprouting forth. No question on this, but then again, what I say today may not be repeated by somebody who sits in my chair 10 years from now, and I can see a legitimate concern, and we're still discussing that.
Thank you. In the name of fitness, I wonder if you'd be interested in an exercise to help stimulate the circulatory system. If you take your right hand and then clap your left hand hard against it in appreciation of our panel.
Are we allowed to do that here?
Thank you very much for joining us on the panel. And if I can now draft the next occupants for the seats here, Sheldon Esbin, David Hopkins, and Scott Irwin.
No, I don't think so.
Oh, you're right.
If it's more convenient for the panelists to operate with your microphones in front of you, or come to the podium. Sheldon Esbin, you've already heard from this morning. He will be available for questions in relation to this subject area. But let's talk a little bit about self-regulation and the activities that go with it. Back in the mid-1950s, an ACA committee joined with the Advertising Agency Association and established the Canadian Advertising Advisory Board. Later, media was added to that organization, and the tripartite organization developed the first of the self-regulatory codes, the Code of Advertising Standards. Subsequently, a number of other codes were developed for different sectors, and this is your opportunity to hear about this regulatory activity. First, I'd like to call on David Hopkins. He is currently operating Hopkins Management Services, but has, as his background, 25 years of successful management experience with Procter & Gamble. During those 25 years, he has been on numerous ACA committees and always done an excellent job. He has been on a great number of other industry boards, and I'll not bore you with the sort of reading of all of them. I should mention, just to show you that you get the absolute best from the advertiser community, that he is also a recipient of the ACA Gold Medal Award for his untiring, calm and devoted service to the betterment of advertising in Canada. He's currently chairman of the Advertising Standards Council, and it is from this background that he will make his comment. David?
Thank you, John. The background paper I provided you gives a little of the history of the evolution of the self-regulatory process in Canada and how the administration of the code works, both in terms of handling complaints from the general public and also trade complaints. As John mentioned, under the auspices of the Standards Council, there are in fact a number of codes administered, and some of those involve mandatory pre-clearance, such as the Children's Advertising Code. I don't plan to touch on that area. I think Scott probably will in relation to advertising to children. I would really like simply to talk in terms of the Canadian Code of Advertising Standards, a general code applicable to all advertising, and the way that is administered by the council that I'm privileged to be chairman of. As noted in the background paper, the code really got its teeth in the late 1960s when advertising was coming under considerable attack, and it was then that the Standards Council was set up to rule on and evaluate complaints that might be made against the Code of Advertising Standards. And the specific support of the various media associations also came into place at that time. And this is really what gives the code its teeth. The advertiser and agency associations are supporting it, supporting the principle that no advertising should be prepared that contravenes the code. And the media associations are supporting the principle that advertising that does violate the code shouldn't be carried on their media. And this is where the crunch comes if an advertiser chooses to ignore the judgments of the council. The council is an autonomous body of volunteers made up of industry professionals and public representatives. And on the council as it is made up today, we have the full council consists of 4 representatives from the advertiser community, 4 representatives from the agency community, 4 from the various media associations, and 7 public representatives, 2 of whom are nominated by the Consumers Association. I should mention that the industry representatives are nominated by their respective associations. In addition to the council based in Toronto that looks at national English advertising issues and also regional complaints that may come from the province of Ontario, there are regional standards councils established across the country to deal with local complaints, complaints relating to local advertising in those communities. And there is also the Conseil des normes de publicité based in Montreal, which handles complaints in the province of Quebec and indeed any national French language complaints. The process involves basically working primarily with the staff in Toronto and Montreal offices, with the full council really only becoming involved when understandings and agreements are not reached by staff working with the advertiser involved. Let me just touch though on the scope of the code. We're dealing with how products and services may be advertised and not whether a particular product or service can be advertised. We're dealing with the process. We're not in a position to prohibit advertising of any legal products or services. We also don't rule on or restrict free expression of opinion or ideas. We're dealing with advertising of products and services. One area that comes up from time to time, we do not rule on election advertising, and this is both because of its involvement with opinions and ideas, and also, frankly, because of the time frame in which it occurs. There's nothing we can do about it in that time frame anyway. We'd be wasting the volunteer group's time. The background paper outlines the code, and incidentally, copies of the code are available from the Canadian Advertising Foundation. There are currently some 16 clauses, and those are the clauses against which the council operates, either the National Council or the Regional Council, in evaluating whether or not the code has been breached. I mentioned in the paper that the code is one that comes under review from time to time, and currently, the one that's currently published was issued in May '86. We are very near to a revised draft. The principles are unchanged, but there are some clarifications that I think are being built into the rewritten code, many of them, frankly, to help us at the council in administering the code. Just by illustration, I might point out that Clause 16, which relates to taste, opinion, and public decency, is one of the ones that we find particularly tricky to deal with. The wording now says that advertising should not contain anything likely in the light of generally prevailing standards to cause deep or widespread offense. And we in the council have had a lot of difficulty grappling with what deep or widespread offense really means and how we should be interpreting it. So I think we're going to come up with some more practical words there that will help us in administering it, but not alter the intent of that clause. The code was originally established to deal with public complaints, and we in the Toronto office normally handle about 200, 250 come through the staff function. Relatively few of these will come forward to the full council because, again, this enforcement process, if I can call it that, means that the discussions that staff have with advertisers who are being complained about are taken seriously, and quite frequently we'll find there isn't a breach of the code involved at all at the staff level. In other instances, the advertiser on it being brought to their attention may agree, yes, maybe there is, and so they will make a modification to the advertising, in which case it then does not go forward to the full council. If the advertiser and the staff are not able to come to an agreement, then indeed the case comes before the council, who will listen to it and come to a judgment, and so advise the complainant and the advertiser what the outcome is. It is extremely rare for us actually to take the next step, which would involve having to bulletin the media that a particular advertisement has not been approved. And this is because the advertisers understand that that is what would be the next step, and so they say, well, okay, we'll change it, and they do. A second facet that I just want to touch on is the issue of competitive trade disputes. And while initially the mandate was strictly to deal with public concerns, it was in the early 70s, I guess, when there was a fairly competitive bout of comparative advertising coming through the industry at that time, that the industry asked the Canadian Advertising Foundation to try to establish a procedure that might resolve disputes between competitors in a way that might be quicker, less costly, and less public than going through the courts. And so what was put in place at that point in time was a competitive trade dispute procedure that involves essentially 3 stages. The first, and this is maybe the most important one, is a mediation process in which the 2 competitors are brought together with a mediator from the foundation or from the council to try to reach a resolution between the 2 parties. And over the history of the process, this in fact has been where most of the complaints get resolved. And that again is because it's done against a backdrop of potentially having the advertising removed from the air or from publication. And if there is some area of negotiation available, then quite often we find that an advertiser in this process is prepared to say, well, I'll change this, and then the complaint may be withdrawn. If that doesn't happen, then we go on to two further stages. The first is the establishment of a 5-person advertising review panel that is set up specifically to hear that specific case, obviously made up of people who are not involved in the industry under review. Again, it is the same type of structure as the council at large, that is to say, the 5 members involved, a representative from the advertiser community, a representative from agencies, a representative from the media, and 2 public representatives. This panel will hear the dispute, hear evidence from both sides, the complainant and the advertiser who's been complained about. They will conduct informal cross-examination. This is an informal process still, and they will come to a decision and will then advise me as the chairman of the council overall, and we will advise the parties involved with the finding of the review panel. The third step, and again, very often that will be the end of the process. The third and final step, however, can be an appeal of the review panel's decision to the full Advertising Standards Council, and again, the process is repeated in that instance, with both parties having the opportunity to present their case and the council again reaching a decision. I reiterate that the process is non-legal, it's informal, and it is also private. Both parties agree in advance not to publicize the resulting decision of the panel or council or the particular issue in question. Also, the council will not handle complaints if the advertiser is simultaneously appealing the issue to a government regulatory body or challenging the advertising in the courts through legal process. Both of those avenues are obviously open to the advertiser either before or after the council has been asked to intervene and has rendered the decision. Overall, the competitive dispute process, I would say, has really worked very well. Certainly in those cases where an advertiser has knowingly or unknowingly, when he did it, been pushing a little beyond the edge of what might be appropriate, then when we get to the mediation process, it quite readily pulls back. There are a couple of instances, though, in fact, 2 or 3, I think, over recent history, where we've got dissatisfied advertisers after the process. This is, I think, the area, I say that we're under reviewing the procedures and systems, and this is the area I think we need to fix up. The volunteer group that we have there are not necessarily well equipped, and we don't have the research capability to deal with highly technical, competitive complaints and disputes. And what we are working on is to find ways that we can both get appropriate resources put against those kinds of disputes within the Standards Council operation, and also, frankly, to make sure that our procedures stand up to scrutiny in terms of fairness, equitable treatment of both sides, and appropriate hearing of evidence and appropriate understanding of the basis on which complaints are being made. I might just clarify that our current procedures involve separate private presentations by both sides in the dispute, with them not hearing each other's presentations and not cross-examining each other. That I understand is an anathema to lawyers, but it has worked very well in most of the cases. But that is one of the areas I think we need to fix up and have better exchange of understanding of where both sides are coming from if we're going to be seen as handling these in a truly equitable way in those issues where there is a particularly close and combative dispute between the two advertisers. Mr. Chairman, I should stop there. I'm sorry. I'm longer than I should.
Thank you, David. To talk a little bit about the broadcast code of advertising to children, we have with us today Scott Irving. He is Vice President Advertising of Irving Toys. He is the immediate past chairman of the Board of Directors of ACA. He has been chairing the ACA committee for advertising to children for a number of years, and he has been constantly and continually involved with the pre-clearance function of the broadcast code of advertising to children. So could you tell us something about it, Scott?
Well, thank you very much, John. Actually, the text I prepared today touches very little on the advertising to children question, not because it isn't interesting and very dear to my heart, but it's fairly specific and may not be interest to everyone in the room here. And indeed, I almost wrote entirely David's speech this morning, but I didn't, thank goodness, so hopefully you won't have to listen to the same thing twice. But I would like to touch on the work of the Advertising Standards Council, because I think that the mechanism they have there to resolve trade disputes and also consumer complaints about advertising is superb. What I like about it is that I believe that the disputes are handled very, very quickly, and when you're talking about advertising with campaigns that are on and off the air in a matter of 3 or 4 weeks, the damage, if any, can be immediate, and going through more normal legal processes can be kind of like closing the door after the horse is already bolted. And I think it's also good that you can go there and really be judged by your peers, and you can hash it out. And I think that that most of these complaints, most advertisers, when they sit down, they look at the facts, they say, "Oh yeah, I shouldn't have done that." And I think a lot of these things are really oversights, or as David mentioned, occasionally someone just going a little bit too far on a competitive point. And I think that the Standards Council carries a lot of weight with national advertisers, that when they say, "Look, we think you're in the wrong in this instance," I don't think there's too many people that will go to the appeal process or go to the legal system. It'll be pretty clear, and I think that the opinions of your peers are to be respected. But what I was going to speak about today is not how to handle complaints, but how to prevent them in the first place. And advertisers have come a long way in cleaning up their act since the days of snake oil pitchmen, and this has come about, I think, for 3 main reasons. Firstly, consumers are far more educated and discerning than ever before. The average Canadian sees about 700 television commercials per week. And television is only one of the many mediums that carry advertising. At that rate of exposure, it doesn't take long for us to develop an educated and critical perspective on advertising. Secondly, the advertising community itself has grown up and matured. With maturity has come an ever higher standard of ethics. The Association of Canadian Advertisers, or ACA, was created in 1914 for the purpose of promoting responsible advertising practices within a healthy environment for business. Over the course of its 75-year history, the ACA has been instrumental in bringing integrity, responsibility, and professionalism to the advertising process. Advertising today, at least for national advertisers, is a process. The process involves industry associations like the ACA, the CAB, ICA, and the CAF. It involves, and if you want to know what those alphabets stand for, I'll be happy to tell you later. It involves agencies and broadcasters. In short, national ads today are not the work of one person, there are many people who get involved, including the corporate legal department. And they're all professionals. So the chances of an ad going to air that is in breach of the law or industry codes is pretty small. The third reason that advertising has reached higher standards over the years is because various governments have, over time, developed laws which have dictated higher standards. This third motivation, government legislation, was very important early on in getting business on the right track. But I would like to think that in recent years, with some unfortunate exceptions that had little to do with advertising and lots to do with making political hay, so that in recent years and in the future, the impetus for reducing advertising complaints will come from the advertising industry itself. We already have the following industry codes in place, and I'll list them because it's quite amazing. The Broadcast Code for Advertising to Children, which John alluded to, the Canadian Code of Advertising Standards, which David quoted from, the CBC Advertising Standards, Code of Consumer Advertising Practices for Cosmetics, Toiletries, and Fragrances, Code of Consumer Advertising Practices for Non-Prescription Medicines, Direct Marketing Code of Advertising for Horticultural Products, Guidelines for the Use of Comparative Advertising in Food Commercials, Guidelines for the Use of Research and Survey Data in Comparative Food Commercials, Pharmaceutical Advertising Advisory Board Code of Advertising Acceptance, Telecaster Committee of Canada Guidelines, Sex Role Stereotyping Guidelines, Television Code of Standards for the Advertising of Feminine High Sanitary Protection Products, and the list probably goes on. The advantage of industry codes over government legislation are many. Industry codes are written by advertising and industry-specific practitioners who know the problems and have the skills to solve problems whilst protecting the advertiser's right to advertise. Secondly, industry codes are living documents. They can be modified very quickly in response to new consumer demands. Thus, industry can solve problems as they occur and before they get ugly. Government, by its very nature, often moves too slowly and tends to solve problems with a sledgehammer after the fact, when only a tuning fork was called for to solve a problem if dealt with early on. That's not to say that government should butt out. The challenge really is for the advertising industry to do their homework and to do the fine-tuning necessary before the government feels the need to intervene. As I said up front, our main concern as advertisers is to prevent complaints, and that the industry is doing a pretty good job of promoting responsible advertising practices. Let me give you two pieces of evidence that tells me that we're on the right track. In 1973, there were 97 complaints received by the Advertising Standards Council about commercials directed to children. During the 1980s, the Standards Council received, on average, less than 4 complaints per year, and on average, upheld none of them. Second, look again at the list of industry codes that I just read to you that have been developed in recent years. And take, for instance, the Fem-High Code and the Sex Role Stereotype Code. The existence of these two codes and their content show that the advertising industry is light years ahead of the old purely legal concerns about things like bait and switch and false claims. Our codes are now addressing consumer attitudes about advertising. We are responsive not only to factual content and truthfulness, but now also to the style and tasteful presentation of our messages as well. Well, if there's no problems, why are we here today, you might say? And I'd like to think that in answer to that, seminars like today's are part of that advertising process that I think raises the standards of ethics. Hopefully we all learn something, we become more professional, we make fewer mistakes, which leads to less complaints. But also in truth, there are still complaints, but I think you'll find that the companies that attract complaints are, for whatever reason, not fully part of the advertising process. You won't find those companies in this room today. They're certainly not ACA members. They probably don't even use advertising agencies. The people who find themselves in trouble and who give advertising a bad name are generally, for lack of a better word, local, fringe, marginal retailers who do the... It's the rug salesmen, the used car dealers, and I stand to be corrected, but I think most of the malpractice complaints that go before the courts today are these types of people who do their own thing, ignorant of both the law and industry codes. The challenge then is to reach out and bring these people and companies into the advertising process to help them upgrade their practices, because their transgressions reflect on the whole advertising industry. In conclusion then, the advertising industry is responsible and responsive, and the maxim, an ounce of prevention is worth a pound of cure, never rang truer. Thank you.
Thank you, Scott. The subject of the pre-clearance process of the Broadcast Code of Advertising to Children, if you have any questions about it, we can still provide answers in that sector. So here you have the 3 targets for your incisive and even for your casual questions. Perhaps I should accord you, Esbin, the same as I did to Katharine. If you have, from what you heard, any questions of the 2 other panelists, you have the opportunity to start the ball rolling there.
Well, I've heard that the process is non-legal and private. As thick-skinned as I am, I got the message. It's not that we lawyers don't want to participate. You know, we do participate occasionally, but it's an industry code, and it should be kept in the family, I think.
Over against the wall. The question is in the area that we probably have the greatest amount of difficulty with, the taste opinion side of the regulatory system. David, do you feel up to tackling it?
Sure. This is the most difficult area for us to deal with, but I think it's interesting that, in fact, the cases that come before us, by and large, are really very clear-cut, we find. Again, I mentioned the difficulty we have with some of that wording of Clause 16, and in fact, the wording that we probably are going to get to in a revision is maybe not very different, but it is saying that advertising should not exploit various things, sexuality, children, blah, 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 in a manner which is offensive to generally prevailing standards. and the specifics that have come before us, we really haven't had much difficulty as a group saying that this is not acceptable, or that this is a joke. I mean, this is legitimate use of humor. In each instance, we would only be looking at it, let me say, if there had been a complaint, so someone was offended by it. But in practice, I don't think we have been using a heavy hand in this area. And in this particular area, there is no pre-clearance issue. It's a question of clause on the area. If there's a complaint, this is maybe the clause under which it's judged. Interestingly enough, I might just add, Johnny, this is an area where the regional council may come up with interestingly different points of view on individual commercial. And when we meet annually the various regional chairs, it's quite intriguing, some of the things, and we share experiences. We're not, the National Council has no control over the regional council. This is not an appeal process, this is a sharing of experiences. But some of the complaints that may be received in the prairie provinces and found totally inoffensive, I don't think would have got through our Toronto Council, and maybe vice versa as well. There are differing standards, I think, that are well reflected in the regional council.
Thank you.
Yes. Well, the time frame that we are trying to work to is basically we should be able to handle mediation within a 1-month period, the review board within a 2nd month, and an appeal if required would be in the 3rd month. Now, we may be able to tighten that up further, but realistically that's about where we are at the moment when we look at the time involved in getting the people together and getting a review panel in place. There isn't really much thought of being able to do this faster without, frankly, prejudging it. I mean, we have to have an opportunity to hear both sides of the issue. And here I'm talking particularly on trade issues. In the case, and this may open up the whole area of putting in public complaints instead of trade complaints, but in trade complaints in public complaints that relate to things that appear to be blatantly in violation of the code, we can handle those almost instantaneously because we have the conversation, staff has the conversation with the advertiser says go to hell, and we go to the council quickly and we get a ruling, and that will not run again. If it is actually done.
If I could add that, some of the major cases are the ones that take that amount of time. One that went public was the Cola Wars, Pepsi and Coke, and they were fighting over principles that could have been part of perhaps several years' campaign, so that even the 3 months that it took to resolve it interfered in the process in a highly meaningful manner. Smaller conflicts, as David says, can be resolved very quickly. Anyone else? I wonder if I could raise a question back to the broadcast code, Scott, I think it may be of interest to this group, the difference that we have in that there is a ban of advertising to children in Quebec, and how does that affect your activities as a practicing advertiser in the field?
Well, thanks for that question, John. I guess that might come under the sledgehammer clause that I was speaking about earlier. Clearly, the advertising code that we have that applies to kids in the rest of Canada is working very well. When you've got less than 4 complaints per year, none of which are generally upheld, that tells me that we're doing a pretty good job. And we've struck a balance where the consumer is satisfied that what needs to be done in terms of regulations has been done and the irritants have been removed, and the advertiser is satisfied that he's still able to exercise his advertising rights. In the case of Quebec, they've gone to a legislative ban on advertising to kids under 12, and that to me is pretty heavy-handed. It doesn't. It's hard for me to believe that someone who's 11 and is going to be in university maybe within 6 or 7 years is incapable of making a judgment as to what candy bar he might want to buy. I think it's an insult to the kids of Quebec. The other ramifications of it are that with no advertising support for children's programming in Quebec, there's no incentive for anyone to produce any children's programming, no incentive for the stations to run any children's programming. And if they do anything, they put on the old stuff that's tired and dirty. So it has some negative results that way. Interestingly enough, in a province that is so desperate for trying to hang on to its culture, it's driving kids to watching U.S. border stations in English that come through on cable with advertising that's not regulated in any sort of way. And so we've got all these little francophone kids that are age 4, 5, and 6 spending up to 21 hours learning English by watching American cartoons. So that's another kind of negative. I think actually if the Quebec government could make it all go away, they probably would, but they've kind of painted themselves into a bit of a corner. It's obviously popular legislation. I mean, if you went out and asked 20 people on the street, could advertising to kids be banned? You probably get quite a few would say yes. Not caring a whit whatsoever for freedom of speech or anything like that, but just because they think that maybe it'll get their kids off the back of the parent and they'll stop asking me for things, which is absolutely untrue. Kids are going to ask for things whether they're being advertised to or not. You just take them to a supermarket and find out what kind of cereal you end up buying, and you'll find that out. So there's some real negatives with legislation, and you can't address the nuances like we have with a living, breathing code that we've just gone through a review of the kids' code that's about to be published, and some phrases have been changed and modified, and I think it's a very reasonable way of handling a problem. Does that answer that?
Yes, indeed. It's of interest, a battle that we revisit with officials in Quebec continually, trying to get them to rescind that, but to get National Assembly to rescind anything is not the easiest thing in the world.
I can't go beyond my time. I can only address what I've been doing, and I've been following the Canadian code. Well, David?
In the early early 19... No, wait a second.
The children's code. I don't think it's that.
Yes,
Early 70s. Well, Irwin Toy's been around since, I guess, advertising on TV since about 1960, 59 maybe. No, I don't think that's the motivation, and at all. Certainly, whatever our policy was in the 60s and early 70s, and I'm not old enough to be privy to what those policies were, but they weren't different in the rest of Canada to what they were in Quebec. They were the same policies. And well, it's not legislation, it's a kid's code, and we're a full participant in the creation of the code. I've sat on the amending committees to the code twice now. So we're, the children's code is Irwin's policy. We helped create it.
The legislation in Quebec, I was there when it came down, and it has done nothing to make advertisers do a better job. It has, as Scott Irwin was saying, killed what used to be some of the best children's programming in the world. The French-Canadian children's programs, in my opinion, rated right on top of anything produced anywhere in the world. And
No, I think that the entire motivation was making political hay. I think it's a popular notion. It's let's protect our children. It's mother and apple pie. It has nothing to do with the advertising that was on the air in the day or the advertising that's on the air now. It's a vote-getting legislation, and that's full stop.
I think we should try to catch up to our timetable again, if I may. Thank you to our panelists for the job they've done. And there should be another coffee break available. If I may suggest that we limit it to 10 minutes, and then we will have the next item unfold for you.
1, 2. Okay, Wayne? 1, 2, 3, 4. 1, 2, 3, 4.
Scott, I loved your comments.
1, 2, 3, 4.
I loved your comments. I was at the time the kids advertising thing was on.
1, 2, 3, 4.
How to do it? The legal aspect of it.
Yep. Welcome back to our sessions. As you are now renewed in spirit and body, we'll begin the last session of the day. This is where we're trying to outnumber you down in the audience from up here. We have a 5-member strong panel, so both Wayne McCracken and I are needed to handle this session, perhaps even step into the discussion as it may unfold. First, I'd like to go back to almost 20 years ago. At that time, a man called Robert McAleer, in a speech to the ACA seminar, concluded with the idea that a group of theologians be approached to make a learned assessment of truth in advertising. This is the time when Ron Basford was the Minister of Consumer and Corporate Affairs, and he was involved in drafting the concept for the competition bill that would have put credulous man in full play. And as such, the truth in advertising would be determined on the basis that would probably have killed all advertising as we know it. At that time, I happened to be the treasurer of ACA on the elected side, and we agreed together with ICA to sponsor a symposium, all the leading theologians, to look at the truth. They quickly rejected the credulous man concept and expected that reasonable man must prevail. They debunked the myth of the advertising conspiracy and pointed to the competitive feature that individual advertisers are motivated by, and that this competition requires some leverage and leeway to bid for business in a competitive marketplace. They were remarkably understanding of the need for substitutions, and you may hear about some examples from the panel that they actually went further than perhaps the corporations themselves in terms of correcting certain areas of substitution, because they held that as long as it didn't improve the look of the product or enhance it, then substitutions in the studio, in the setting of advertising production would be quite allowable. They established the principle that the advertiser must be held responsible for the message as received by the audience, not the literal part of the message that you're sending. In my opinion, it added a great deal to the understanding and legal provision that followed from that and became the competition bill as we know it today. Enough of that. Now to our panel, and I'll ask my co-chairman to introduce this substantial panel.
Most of the panelists have already been introduced by John or myself earlier today. Three down from me, or 3 from the other end, is Jack Bram. Jack is Vice President, Backer Spielvogel Bates, a major advertising agency in Canada. He has worked with agencies for 30 years, has an extensive background in advertising regulation and in the industry, was a member of the Joint Broadcast Committee of ACA and ICA. Jack is here to speak from the viewpoint of an advertising agency in the advertising process and the management of advertising. Second from the end is Ken Fong. Ken is Vice President, General Counsel of McDonald's Restaurants. Ken is involved in many, obviously, of the legal aspects of McDonald's undertakings, and importantly in the legal management within his corporation of advertising. As you know, there's no corporation in Canada, and certainly in my opinion, which has been more successful in advertising and marketing. And Ken is therefore, if not uniquely, certainly very well qualified to speak to the role of in-house counsel in relation to the management of the legal aspects of advertising. In putting together this panel this afternoon, our objective was to try to get an interplay from people responsible for the creation of advertising. So we have Bob Galloway and Scott Irwin and Jack Bram, and from the in-house and outside counsel viewpoint, and see how problems in the managing of all these laws that apply to advertising that people want to run and promotions that they want to develop, how one can manage these in a creative way, what problems arise, what solutions and suggestions people have. But what I'd like to start with is Bob Galloway. Bob, you develop a brilliant concept. How do you work with the lawyers? You know what we're talking about.
Well, just in a couple of minutes, I'd like to talk about the partnership between the legal person within a corporation or within the outside counsel and the advertising manager, as we'll put it, the practitioner who's developing the advertising. I've been extremely fortunate because I've always had a legal partner with me who believed in the process to start with. And together, it's a team effort to produce the material. I think in the team, this two-team, the legal person probably is the most concerned with fact. You might disagree with that, but I think fact for sure. The advertising part of the team, the advertiser part of the team, has to be sure of the perception that will result even though the facts are correct. And he might have to go to the consumer with tests or whatever to make sure that the rendering of the facts have a perception which in itself is not misleading. Now, if I may, I'll give you two examples of what can happen even if the facts are right. Many years ago, the FTC brought Campbell Soup Company to task for a famous case called Marbles. And this was soup that had the proper distribution of garnish and broth, but when it sat in a bowl and you took a picture of it, all the garnish went to the bottom and all you could see was a flat, uninteresting surface. So we had been using the practice of buoying up the garnish with marbles so that when you took the photograph, it looked somewhat like it would look as you turned it with a spoon, which was impossible to do and take a picture. The ruling was that was misleading, and that's a famous case. So that brings up the whole question of what do you do in terms of together approving. Do you use mashed potatoes if you're taking ice cream? What do you do if you're taking meats? Do you really use meats? And so that's the whole area of fact versus perception. The second one is a Canadian situation, and this alludes to a comment made a few moments ago about female and male perception. We have a commercial produced which are called Mom's Night Out. A father is sitting in the kitchen with his daughter. The daughter's 5 or 6. Mom is still in the house, but she's ready to go out that night. The little girl prepares Campbell's tomato soup for her father and brings it over to her father in a mug. And they both sit down together in front of television, and he's enjoying what his daughter has prepared for him. And he looks at her and says, "What are you doing tonight?" And she looks up and says, "Nothing." And the scene closes. Well, we've had a very difficult time with that commercial. We are accused of incestuous advertising. Now that's fact. David will attest to that. Then this week I heard the other side of the equation, that is demeaning to men, because the only thing a man can do in a cooking situation is heat tomato soup. So there's a difference between fact and perception, and frankly, perception probably is the most difficult and the most important in the final analysis. Now, I'm great for lists. I'd like to give what I think an excellent legal partner to this equation should do. First of all, have an open mind, and if one has a bias against advertising, pass it on to a partner who's an advocate. The second, look for factual problems and point them out, but don't rewrite the copy. Examine the ad for its relationship to intellectual properties, as we discussed this morning, because I think specifically advertising and trademarks are very importantly linked, and advertising can ruin a mark or build a mark over time. We all know that advertising people are procrastinators, so they have no time, so help them by moving quickly. Don't assume that the agency has checked it all out. Make sure that you check it out yourself. This other one is very important, and we have time to elaborate on it, but ask or know that your advertising people have procedures and guidelines. Guidelines with respect to photography, for instance. What I said a moment ago about what are you taking? Are you taking real food, or are you taking something else? And a factual supporting document which allows them to work. And Ollie wouldn't agree with this one this morning because I tried it on him. Try as legal people to get into the creative process early if you can, into a creative session, or at least see the creative strategies early, so that when the material is brought to you, you know approximately where they're coming from. Thank you.
Bob, Ollie is perfectly capable of speaking for himself. I was present this morning, and I think Ollie's observation was not that he had in any way disagreed with the eminent desirability of getting in early. There's a rather important question, of course, on the part of an outside counsel, and that is a client prepared to pay the cost of that?
That's exactly what I raised with my friend Bob this morning. It would be ideal from my perception if I could watch these models getting modeled, but you can't afford to have me hanging around there.
I'd like now to ask Scott Irwin to add his observations and experience to what Bob Galloway has kicked up.
Thank you very much. In the previous session, I guess I was supporting the CAF position that we really don't need lawyers to solve our trade disputes. And CAF is a wonderful mechanism, but I saw Shelley's face kind of go glum. So I think we should leave a little money on the table for the lawyers, and that's in this section. From the advertiser's point of view, doing it right the first time is paramount. Advertisers should take the time to have their advertising material legally blessed as a normal part of the production process. Fixing it in the field can be very expensive. It's the old pay me now or pay me later, I guess, and a little bit up front saves you a lot later. Story comes to mind of the U.S. advertiser who ran a promotion which involved giving away $10 to consumers who correctly answered a mathematical question. One enterprising consumer solved the problem and used his computer to print enough entries to entitle him to $86 million. In the contest rules and regulations, the advertiser had failed to limit the number of entries a single person or organization could make. Legend has it that they settled out of court for $8 million. So once again, an ounce of prevention is worth a pound of cure. Many advertisers have their own legal departments which are plugged into the production process. But even if you don't have an in-house legal department, your system for producing advertising should include a legal sign-off that can't be circumvented. And that's tough for advertising guys because we work, last minute and everything, and it's difficult sometimes. There are many outside legal firms, I'm sure lots of them in the room today, that specialize in advertising matters such as copyright, contests, and sweepstakes. If your company doesn't have in-house legal staff, you should be using the services of one of these firms. Often your advertising agency will have a working relationship with a firm that can review proposed advertising material for legal purposes. In some industries, alcoholic beverages, for instance, very specific legal expertise is needed to work the advertising material through the minefields of provincial and federal legislation. Obviously, the selection of your source of legal advice becomes critical. A legal expert in your field will cost more, but his project turnaround time and expertise will be worth it. One other legal aspect to advertising which is of concern to advertisers is copyright law. And I'm not a lawyer, but as an advertiser, I know that advertisers need legal advice in this important area. At issue here is the question of who owns your advertising material. An advertiser may have bought creative, yet not have outright ownership of it. An advertiser may indeed own the material, but still may not control the uses to which the material is put. Something called author's rights comes into play here. There are indeed instances of authors who have sold their works outright to people, yet can reach out even years later and exercise control over the uses of the art. The bottom line here is that you may not have the right to use the photograph you bought for that print ad on your packaging, for instance, or in your annual report, or in another country, unless you have a legal uses contract with the author, which in this case is the photographer, up front. So my advice is for advertisers to seek legal advice in this area. And that's all I have.